And for me also, it's a pleasure to be here and, associating with the Controller General's, scheme or objective of spreading awareness on the intellectual property rights.
Ma'am, are you there? Ma'am? लीव हो गया? अच्छा ma'am, so due to some technical error, I think ma'am has left the meeting. She will resume in shortly. Okay, ma'am is here. I think कोई technical issue की वजह से मैम left हो गई थी. Ma'am, are you there, ma'am?
Yes. There was a technical glitch in the starting only. I'm so sorry for that. So I am sharing the screen once again. Please let me know, right?
Ma'am, उनको share कर.
Okay, screen visible hai?
Yes, ma'am.
Okay, let's start now. So we all are talking about the intellectual property. So I would like to give a small introduction about what it is actually, and because nowadays there are so many awareness programs going on regarding the intellectual property, and why does government want us to to be aware about it, and what is its importance? So we all know about the physical property like house, car, all these kind of these type of properties are actually the physical property. Your mobile, your bike, so all these are physical property, any land area owned by anyone. So what we are not sure is like what is intellectual property. So intellectual property is something which is created from your mind, which is created from your energy, from brain, and something creative. And we will see that there are actually different types of intellectual property. It depends on the type of creation that you are talking on or that you are working on. So if let's say if there is something which like you have invented or some kind of technology, then that technology can be protected under patents. if you have created some or developed some creative design of a product, like design of a bottle, if you see like the bottle of Coke, Pepsi, in fact, all those creative designs are also, it can be protected under the Indian Designs Act. If you can see, so this is a jar. So this has a specific design. So the owner of this particular bottle, they would have protected its outer appearance or the final shape. So the final shape of any product, it can be protected under the Designs Act. We have seen that there are a lot of trademarks or logo through which companies do their business. So those kind of marks or those kind of slogans or lines which help them to to recognize or put an identification in the market for themselves, those kind of symbols or taglines are protected under Trademarks Act. Geographical indication, so if there is something which is related to a specific geography, then those kind of things can be protected under geographical indications. Like, for example, the Assam tea. So that particular kind of tea can be developed or can be produced only in Assam. That is because of its weather conditions and geographical conditions. So that is why those kind of features can also be, or those kind of things can also be protected under the Act of Geographical Indications. Next is copyright. Copyright is an act which provides you protection on if you create something which is any kind of literary work or any picture or any book, so any poem, songs, so all those literary or artistic work, it will be protected under the Copyright Act. Semiconductor integrated circuits, so all the integrated circuits and layout designs of the electronic circuits, those things can be protected under the Semiconductor Integrated Circuit Layout Designs Act. So because the nature of intellectual property is different, that is why there are different kinds of there are different types of intellectual property rights or act which protect different types of creativity or different types of intellectual property. So is someone raising hand? Passcode if you want to ask any question. If you have any questions, please leave in chat. We can take it at the end, I think. So I hope it is clear that we are talking about intellectual property, and intellectual property is something which is created or which is developed on the basis of your brain or on the basis of your intellectual capacity. Physical properties, we can buy it just by paying cash, but intellectual property, it can be generated only by the way of your creativity, intelligence, and that's it. So the protection which is provided for a physical property, that is also protected by the Government of India. Likewise, intellectual property is also protected by the government. So we have these specific laws and specific rules through which these kind of creativity can be protected by the government. So it is not so the intellectual property is properly valid and in the existence in the whole government, whole jurisdiction of India, and it is regulated by the Government of India. Now the next slide. So if you can see over here, there are different types of intellectual property which we were discussing. So even a single product can also be the combination of all types of intellectual property. So taking this example of laptop, this the technology part like LED display and how does it function, that can be covered under the patents. Now the body of laptop, like the way it is manufactured and the outer structure, that can be protected in the Designs Act. Now we are looking for the Apple sign on it. It means that Apple company has produced or developed this laptop. Now this particular symbol is protected under the Trademarks Act. Now, with the laptop, there would be a user manual. That user manual can be protected under the Copyright Act. And then the layout of integrated circuit, it will be protected under the SICL Act. So I hope now you would have understood that how different types of intellectual property interact, and there could be the simultaneous or multiple existence of intellectual property, and then therefore a single product which goes into the market, it can be protected under various intellectual property act and laws which are prescribed by the Government of India. So as I mentioned, that intellectual property is actually the combination of what? First of all, your intellectual creativity, that is brain. Also, it has to be combined with the resources, and then finally, when you streamline your ideas and you develop that thing and obtain a particular product, then thereafter the whole property, or it takes a final shape and which can be protected. So what is the importance of intellectual property? Why should we protect it? For example, if I have developed anything, why should I register it? Is it important to register? Yes. Because when I register an intellectual property, it means it gives me an exclusivity. I will be the owner of that intellectual property, and no one else can use that intellectual property without my permission. So they will have to take my approval or my permission. This is the benefit of having ownership of an intellectual property. For example, if I have a patent on any technology, so only I will be able to use that technology once that patent is granted for 20 years. And if someone else wants to, use that technology or take a license, use it in any way, they will have to take the owner's permission or the license. So the feature of exclusivity, this is very important. So first of all, by filing the application or registering it with the government office, I am protecting it, and I am telling to the government that this is my technology and I want to protect it. And once it is protected and granted the patent or the respective intellectual property regime for that respective property, thereafter I can exclude others from using that particular technology or the intellectual property. And so when I exclude others, I also simultaneously get the benefit that I can utilize that technology, I can license it to someone else, and through which I can earn the money. So it is not necessary that if I have got the patent, that I only have to manufacture it. I can still license it to others and get benefit from there. So what is intellectual property? In effect, intellectual property laws gives the creator a new and unique, product or idea, but it is for a temporary monopoly. It is not like that it will be available or it will be for forever. It cannot be like that. It is for a specific time period, and that specific time period is 20 years from the date of filing. So intellectual property is valuable because it represents ownership and an exclusive right to use, manufacture, reproduce, or promote a unique creation or idea. So this is what I explained in the earlier slide, that when I get ownership, it means that I would get an exclusive right to use it, manufacture it in any way. And if someone else wants to use that particular thing, they will have to take permission from the owner for using that kind of technology. Now we will specifically dig down on the patents. I hope the different type of intellectual property rights and the basics of intellectual property is clear to all of you. And if you have any question, you can let me know in between. So what is a patent? Patent is also a type of intellectual property rights. So in the earlier slide, we saw that their intellectual property right, it is basically a common term of all the kind of creativity, which could be an intellectual property. So intellectual property right, it includes your book also, which has been written. It includes a technology also, which has been developed, and it includes the trademarks also. But when we say about, or when we talk about patent, it means we are specifically talking about some kind of technology, right? So when we are talking about any technology, technology means something which is related to a technical product or a technical process. So all those kind of things, anything which is based on some technology, it can be protected under patents. So patent right is an exclusive right to a technical product or process that generally provides a new way of doing something, and it offers a new technical solution to a problem. So basically, all the inventions cannot be, patented. There are the specific requirements, and unless your technology, the requirements, it cannot be patented. So we will see the requirements in the later slides. So patent protection means that the invention cannot be commercialized, made, used, distributed, imported, or sold by others without the patent owner's consent. So the basic things about these are the basic laws. So if I say that that I have got something trademarked, or I have got the protection on design, or I have got the protection through patent. So each of this protection regime, at least this is basic, that no one else can use it without your permission. So likewise, when we talk about patent, which means that patent will be owned by the owner only, and no one else can use that technology without the permission of owner. So this is very relevant thing. People think that if we have got a patent in India, it means that they can, it is applicable throughout the world. It is not so. So patent rights are the territorial right, which means that if you want to have a patent in India, you will have to file application in India. Likewise, if you want to file application in US, Europe, you will have to file the respective patent applications in US and Europe. It cannot happen that you file in India and you get the protection in US and Europe also. So I hope this is clear, that wherever we want the protection, we will have to file a separate patent applications in all those countries, because patent rights are territorial rights. Now, why institutes like you should file the patent application? So we have seen a trend of last 5 years. So you would have seen that there nowadays, most of the institute, they are very, active in filing patent application. Why it is? Because first of all, it directly correlates with the kind of research that is going in that campus or in that institute. So if someone has filed a lot of patent application, you can think of at least this particular institute, or PhD scholars and faculties, they are involved in some kind of research, and that is why they are filing the patent application. So I hope this is clear, that more the number of patent applications, and it directly indicates that yes, the level of research is good in this particular institute. Now, exclusive rights. So for example, if any institute or university, they have got a patent, so it is not necessary that they have to manufacture it on their own. So they can also license it to the other companies or any micro, small, medium enterprises for the manufacturing of that particular product on that patent. So that way is also, first of all, it's it's a pride for institutes and universities, and also it's an opportunity for getting a financial benefit out of that technology. So this is the data from the Patent Office annual report. Actually, each year Patent Office publish their data, and the main things, for example, how many applications have been filed, etc. So this is the data for the universities only. So you can see that Sanskrit University, it has filed maximum patent applications in last year. which is 703. 703 patent applications have been filed. In fact, Chandigarh University, they have also equally filed 703 patent applications. And thereafter, IITs collectively, which means the combined number of Bombay, IIT Roorkee, IIT Kanpur. So around 597, around 600 patent applications they have filed. Then Lovely Professional University has filed 530 patent applications. Like Chandigarh Group of College, Galgotia has also filed 417 applications. And Tirthankar Mahavir University, they have also filed 404 patent applications. Shobhit Institute, they have filed 224. Amity University has filed 203. GLA Mathura has filed 126. So you can see that a lot of institutes are filing so many patent applications, and it is very good to see these numbers. So I have, included some slides on some questions that we often get asked by the clients. So most of the times, what we hear is that people think that patents are granted to only complex technologies. But I would like to clarify it. It is not so. In fact, it is a myth. So patent can be granted to simple technologies only. Only thing is that there are few requirements that needs to be qualified or those needs to be complied with to obtain a patent, which we will see in the further slides. Obtaining patents is not always about inventing highly complex technologies, rather a simple invention solving technical problems. So there are a few points. Like first of all, you just identify: are you going to solve any technical problem through your invention or through your patent? And then find out that whether this kind of solution was already provided by anyone else or is it new. If it is new, then you will have to see that does this invention or does this product kind of advancing some kind of advancing that technology through any way. So we will deep down into all these factors in the later slide, and maybe then it will be very clear to all of you. So the message through this slide which I wanted to give is that a simple invention can also be patented. So I remember an example or a case where we were able to get a patent on a grass cutter machine. So the grass cutter machine was already known. The new thing was that inventor, he has devised or he has manufactured the blades in such a way, or there was a specific angle of that blade which helped in the cutting of grass efficiently. And that particular angle, it prevented the choking or stucking of chopped grass in that particular in the blades. So that was the novel and inventive part, and in fact the patent was granted for that grass cutting machine. So you can see that it is not always about that you have to have a very development laboratory, I mean, or too much things to get a patent. It's not so. Even when you are in your daily lives also, you can come across with a good idea that can have a potential to get patent. So these are also very interesting question. People think that for patent is so we get a lot of queries like that inventors define that, okay madam, I have this idea, and they just explain it, but they say that we have not produced it, right, or manufactured it. So it is important that whatever idea you have, it has to be converted into a product or a process, because when this application will be filed, it will be examined by the patent office. And during examination, the patent office examiner, they will not come to your laboratory or your campus. So whatever you submit in the patent specification, that will only be examined. Thus it is important that you define each and everything, that how things are working in your specification. And so for doing that, for writing a specification nicely, you will have to see that how your idea is actually converted into a product and how does that product functions. So it is important that whatever idea you have, it has to be converted into a technical product or process. So an invention can be a product such as a chemical compound or a process, for example, a process of producing a specific chemical compound. So basically, what I mean, if the final product is covered, can also be protected under patents, and its process of production or its way of manufacturing or way of working, that can also be protected under the patent. So when we receive the invention from the inventors, we see that what all aspects can be protected, and then thereafter we try to cover all the aspects. So are all the inventions patentable? No, all inventions cannot be patented. So there is a specific section 3 under Indian Patent Act which defines that these inventions cannot be patented. So, however, it may be very inventive and very creative. So some examples I have included here because section 3 in itself is very elaborate. So a different presentation altogether will be required for its detailing. But just to give you a general idea, like mathematical calculations or formulas, game rules, lottery system, teaching methods, surgical procedures, it cannot be patented. So like surgical procedures, so there are two issues. First of all, it cannot be, it cannot be produced in the industry, or it cannot be used in the industry. And second is the ethical reasons also. That doctors who are like, doing this surgery and all, so they cannot have an exclusive right on a particular kind of, way of putting or operating the surgery. Rather, the medical devices, they can be protected and they can be patented. Likewise, plant varieties and animal breeds, they can plant varieties and animal breeds can also not be patented. In fact, there is a specific and different regime through which the varieties can be protected. Likewise, computer programs, algorithms, these are also not patentable, but there are few exceptions and provisions through which you can get a patent regarding the computer programs and algorithms. So if you are solving some kind of technical problem and your algorithm or the computer program is accompanied with some kind of hardware system, then it is possible that patent office may grant a patent on it, provided it qualifies with all the criteria. So this is the general process, what happens after the patent application is filed at Indian Patent Office. So first of all, the application is filed. Thereafter, the application will be published after 18 months. So till 18 months, the application is under the hidden. I mean, it is not published and it is not open for the public domain. But there is an option that if applicant wants to get the application early published, it can happen, because nowadays people want that their application is granted quickly. And till the time this, publication does not happen, the application will not move to the next stage. So the next stage is request for examination. So once you file this request for examination, then the patent office will examine your application and they will issue an examination report to you. Now the examination report will be in the form that in whatever technology your invention is, patent office will try to find out that whether that particular technology is new or not. And they will most probably cite few of the documents which are closer to your technology, and they will ask the inventor that how it is different and how it is advancing the technology, and why should we how does it matches the criteria which is prescribed by the Indian Patent Act. So, so we have to, applicant has to respond to the examination report. The patent office will again review your response to the examination report, similar to your publication process, where you send your publication journal to the journals, and then they review it, and then they send you queries or questions. So likewise, here in patent office also, they will examine your application and they will send you an examination report according to them. Then you will have to address all the objections of the examination report. You will have to answer all the requirements, and then the patent office will review your response response, and then thereafter they will decide the patent application finally. So the application can be directly granted if the controller will be convinced by your response. If there would be any other objection, any formal objection, any technical objection, then they will appoint a hearing as well. And hearing is either face to face, and or otherwise nowadays it happens through video conferencing, like online mode. So at that time you will have to explain to the controller that what is your invention, what is your technology, and how it is different or novel and inventive with respect to the cited documents. And then the controller will finally decide that whether the patent should be granted or not. So what is the term of the patent? It's 20 years from the date of filing of the application. And once the patent is granted, it has to be maintained by paying the renewal fee. So it cannot happen that you just file the application and then thereafter you don't pay the renewal fees and it's done. So for maintaining it, you will have to pay the renewal fees. And in case if the applicant fails to pay that renewal fees, it will cause the application to lapse. So patent office in that case, they will consider that the applicant is not interested in pursuing the application and they will lapse that application. And that way it is a message goes to the society that, okay, now this particular technology is available to be used by anyone in the public domain. So these are the patentability requirements that I was talking about. That first of all, your invention has to have at least one new technical features which makes it different. So let's take an example of a refrigerator. Then your refrigerator should have at least one new feature. So nowadays there are a lot of technologies coming which which claim that this particular technology is useful for keeping the vegetables and fruits more fresh. So likewise, the new refrigerator, if you are coming up with, it should also have some new technical feature which you can say that this particular feature was not there in any of the refrigerator which are there in this market, or if it was published anywhere, it should not be there. Second is the inventive step requirement. Inventive step is basically that how you are advancing the technology. Means what is the technical feature that is making your refrigerator more better in terms of functioning as compared to the other refrigerators which are present in the market or which are published in any literature or in any journal. Third is industrial applicability, which means the product out of your invention, it should be capable of being made or used in the invention or in the industry. So that is why if you remember that the surgery on human, it is not patentable because it cannot be applied on industry, right? So now for novelty determination, how do I, if I have like come across with an idea or with an...
Ma'am, sorry to interrupt you here. Actually, there is an announcement for our participants. Please fill the feedback form. It is very necessary for getting the certificate. Again, please, all the participants fill the feedback form. It is already circulated. Please fill it. Ma'am, please continue.
Okay, thank you. So I was saying that if I have come across with an invention or with an idea, how do I determine if it is new or not, if it is novel or not? So I'll have to perform a prior art search. What is prior art search? It says that, so I'll search on the websites of different patent offices like European Patent Office, US Patent Office. So there are paid databases also which compile the patent journals or information from all the patent offices, and then they give you a comprehensive result. So basically the concept of prior art search is to find that there is nothing related to the technology or idea on which I am working. Okay. And it is very important because what happens, for example, if you do not perform a prior art search, then you do a lot of work and then maybe you have completed your research and finally at the time of product, formation or production, then thereafter you find out that, okay, this was already done and your work is not novel. Likewise, if when you file the patent application, then patent office will do their own novelty search. And if at that time they find out something, very close to your invention was already there when you file the application, so they will not grant you patent. So that is why it is important that you do a prior art search before you start your research, or your invention, working on the invention, so as to determine at least that your application should have one new technical feature. So if something is known outside India, it cannot be patented in India. What does it mean? Actually, we get a lot of queries like that, that people think that if something is present in US, but it is not there in India, so they can get a patent in India. It is not so. So whatever you have to provide, whatever you are thinking on to get a patent, it should be new entirely in the world. It cannot happen that something which is there in US and Europe, since only for the reason that it is not there in India, so we can copy that idea and get a patent. So it cannot be possible. So your idea or your invention, it should be new throughout the world. And even your oral presentation. So for example, if I have an idea at this time, and I have not filed the patent application right now, and and if I disclose it in this meeting, so even this kind of oral presentation or disclosure of idea can be considered as novelty disclosure. So let's say if I have disclosed anything over here, and then I file a patent application tomorrow, and then someone comes up and submit this recording or some kind of proof that I have already disclosed this idea and everything, and now it cannot not be patented. So patent office will consider that thing. So the message from this particular slide is, first of all, do a prior art search before you start, your research. Second is, unless you file the application, don't disclose it to someone else. There should not be any disclosure, and most importantly, there should not be disclosure at places where a record could be maintained. Okay. So the search will help us in identifying what part of the invention is already known and what is new. So let's say if we are focusing on developing some medicines on a particular disease, let's say. So the search will help us in identifying that, okay, this part, till this stage, the things were known, but in this direction, let's say, there is no knowledge or there is no disclosure. So this is a new path through which we can, commence our research. It will help you to focus your research, that this is the main point through which we can perform research, and like that. So, and in case of close or overlapping results, it is suggested to modify your invention. Yes. So if you get very close result, which means that the same idea was already present, then in that case, if you file patent application for your invention, patent office will not grant patent. Why? Because something was already known, and they cannot grant patent if something is not new, right? So the prior art search, it also helps you in identifying the overlapping part and the new part through which you can modify your research at right time. So this is an example. Let's say the filing date is denoted by blue color. So everything which was published before the filing date, it will become a prior art for you. And prior art means that this kind of disclosure, it will be considered by the patent office, and they will say that your invention was not new when it was filed. Why? Because it was already present in the form of a product, because it was already present in the form of publication, and like that. So these are important tip points. Don't publish your invention before the filing of application. No presentation on research, no sale of products, nothing. And invest good time in prior art search. Why? This we discussed in the earlier slide, that more you do research and you will have a good idea that what is the new thing and what are the overlapping thing. And everything published till yesterday is a prior art for the application being filed today. This is the second criteria. Inventiveness steps. So how do we justify, or how do we how do we qualify the inventive step criteria? Novelty, we have understood that if we are able to find out any new technical feature, then we can say that we can submit to the patent office that this is our new feature. But for inventive step, we have to show them how our new product is functioning better, how our product is advancing the technology. Because for something which was already there with the same features, patent office will not grant a patent. So if we are using, let's take the example of refrigerator. If we are not able to improve something, then we will not be able to get a patent. So that is why focus on the problem existing in the prior art. Or prior art means the knowledge or the product which are already there. So focus on the products and the knowledge which are already there, and then try to find out the solution for those technical problems which is there. And there is always and a possibility to improve the functioning, or everything regarding a technology. So where your invention will be searched, when the patent office will be considering or examining your application, they will search your application throughout the world across the database of all these countries. Now, as I was mentioning regarding the inventive step, the first thing, so these are the approaches through which your application will be examined when it will be submitted to the patent office. So the examiner at that time, he will search what kind of technical problem is being solved by your invention. Are you solving some technical problem? And what is the technical solution that you have brought in? Then thereafter, that solution will be examined whether it was present anywhere in the world, through products or through publication. So only those technologies which were not present anywhere and which are able to show some kind of improvements over the existing product, only those will be proceeded for the grant of patent. Now, when we see the test of inventive step, so it is a subjective assessment, which means that it will be compared from the things which were already present. So we will have to show the improvement over the existing knowledge or existing idea which was already there. So this is one example. So in this example, we are producing or developing a vehicle, and what we have done is that in this particular vehicle, we have included the lighting apparatus, and we have also included the wiper apparatus. But this thing cannot be considered as inventive. Why? Because if you see the two additional features, the lights and the wiper, it was already existing in the domain for their own function. So that is why we are using the existing things for their known function. It cannot be considered as inventive, because whatever you do, it should not be obvious to a person skilled in the art. The second example is, let's say we are having an example where there is a process for extracting latex. Now, for extraction of latex, if our process, it produces more pure product and it has more yield with respect to the other existing process, then the patent office will say it, yes, that this particular process is inventive. Why? Because we have been able to produce more product and more quality product. The third criteria is the industrial applicability, which means, as I described earlier also, that the invention, basically the product resulting from your invention, it should be capable of being made or used in the industry. So for example, if a person invents a trick of eloping from a particular place, so however it may be very fantastic idea, but it cannot be patented. So I wanted to put some stress that what happens during the examination, because examination is the very important step once you file the application, because filing of application is not that difficult. Everything starts from the examination stage. So that is why you have to be, once at the time of filing application, just focus on that, whether all the parameters have been met or not met, or your invention is novel or not, inventive or not, so that your application will undergo smooth examination and can be granted a patent. So all inventions are not patentable, as we have seen. We have to qualify with all those three criteria for getting a patented. Who performs examination? Examination is performed by the controllers at Indian Patent Office. And then what kind of examination is performed? So all the technical requirements as well as formal requirements will be examined, and then thereafter the applicant will be sent the examination report. The patent prosecution, it begins with the request for examination. Yeah, so once you file the request for examination, then thereafter examination will happen. The time period for responding to the examination report is 6 months, and then as I discussed that the patent may be granted directly even on the basis of response to appear, or otherwise a hearing could be appointed. How do we overcome the objection of novelty? You have to pinpoint and identify the different technical features, and that's how you can meet the novelty objection. Inventive step objection. So you'll have to explain that why the cited documents, even if they are combined, why a person cannot reach to your invention just by going to the cited documents. So meeting the inventive step objection is little tricky, and I think you will need a professional help for for overcoming this objection, because first of all, it is a subjective objection. So it needs to be identified that what is disclosed in the cited document and how those teachings cannot be or cannot lead to your invention. So this is how the website of Indian Patent Office looks. The website is ipindia.nic.in. You can also visit the website, and there are so many content, so much very nicely made website. You can always visit there, go there, and take its benefit. So I think we are at the end of the presentation. We'll take so these are few queries, a few questions for you all, and I think there are few hands which are being raised for some questions. We can have those questions as well. In fact, we can have the questions as well, and we take these later on. Yes, please. So you can ask the question.
Participant, please ask your question. Ma'am, there was a question earlier that a paper from our audience, that if a paper is published, that paper can be patented.
No. So that is why whenever before filing, or before publishing anything, first file a patent application, and then thereafter you publish it. If you are publishing it first, then Patent Office will not consider your patent application as new. So always the trend or the process that we have to follow is file the patent application first and then go for publication.
Okay. Any other question from audience?
Well, I want to ask a few things. The first thing was that what are the opportunities for students and those who want to go in this field, to pursue a career in this field?
So there are various opportunities. For example, the technically qualified people or students, what they can do is that they can go into the patents. So there's a patent agent exam also, which is out for this year as well as of now, and it comes each year. So you can prepare the Patent Act and you can appear for that exam, and if you get qualified for that patent agent exam, so it will be, then thereafter you can work or practice before the Indian Patent Office as patent agent. And if someone is not is not from the technical domain, they can also still but they will have to do law in that case, and after doing law, they can work in the areas of trademark, copyright, and like that. So for technical people, technical students, they can come to the patents practice, and the non-technical students, they'll have to like do LLB, and then thereafter they can practice before court, and in fact from before the trademark registry for the protection of trademark and like that. And in fact, so for management students also, because they would also need to be, because sometimes I've seen that management students, they are also highly involved in, in the management of the intellectual property of the company. So wherever you go, it will be, I mean, the knowledge of intellectual property will always help you. You can always suggest or you can advise your company that these things are your intellectual property, and they should not put it in the market before the right protection.
So scope is, according to you, ma'am, the scope is very broad. We can pursue career in government as well as the private sector.
Yes, sir. Yes, sir. Right. So there are a lot of opportunities. In fact, the patent office also, they keep on, putting the vacancies or requirements for new consultants in patent and other IP domain as well. So maybe you can qualify that as well, and you can appear for those interviews and exams. So government opportunities are also there, and opportunities in the private sector like law firms is also there, and wherever intellectual property department is there, even there also you can apply. Students can apply.
Any other question from participants?
Well, are there any internship opportunities for students?
Yeah, so how does it happen that students, they actually apply to the central email ID of the law firms and wherever they want to like get the internship done. So you can write to the law firms and then they will respond accordingly to you. So it's a general thing. I mean, internships always, there is always the space of internship at law firms. At least 2 to 3 year, 3 to 4 students are always interning throughout the year. So you can write to the law firm and they will reply you as per the availability of them for having you.
So thank you again, ma'am, for this beautiful slide and the great information. Actually, बच्चों के लिए, स्टूडेंट्स के लिए ही नहीं, और हमारी फैकल्टीज और जो भी पार्टिसिपेंट्स हैं, कुछ ना कुछ डाउट पेटेंट को लेकर हमेशा रहता है. जैसे कि आपने एग्जांपल दिया कि कौन सी चीजें पेटेंट हो सकती हैं, कौन सी चीजें पेटेंट नहीं हो सकती हैं. लाइक अ स्लाइट इन्वेंशन इन द ग्रास कटिंग मशीन जो आपने बताया, एंड द टीचिंग, एक्चुअली एक वो बात भी है, टीचिंग मेथड्स, हम तो टीचर्स ही हैं. वी यूज्ड टू इवॉल्व न्यू मेथड्स एंड डॉक्टर सर्जरीज can't be patented. So it's a very informative session for all of us. Or how patent office is changing, or through the taking the review through the video conferencing. Now I would like to request our principal sir to please enlighten us with your words. Principal sir. Sir, hello. Sir, are you there?
In the meantime, I just ask a question that like in drugs,
Yes,
there is something like process patent, and the final drug is produced and it can be produced by different processes, different routes. That just I want to know.
Yes, sir. Yes, sir. So see, there can be, so there are different scenarios. If we are if we are developing a new product, that is all very fine. So let's say if we are researching on tuberculosis treatment. So we can have a patent on the drug to treat tuberculosis, and we can also have the process patent for producing that tablet or that pharmaceutical composition which will be useful for the treatment of tuberculosis. So let's say if there is a chemical compound, I mean same drug can also be produced by different processes also. And if the process is new, then people can have patent on different process as well. So it is not necessary that product should also be new. So maybe if there is a product then which has got expired, I mean which has completed its 20-year time period of patent renewal, and it is off patent now, then in that case also different processes for obtaining that particular drug can also be patented.
Like suppose it is within the period of 20 years, a drug has been manufactured, and it is an important drug for diseases. So someone produce it by different route. Can he produce it, and can that company produce it and sell it in the market?
It is possible, but sir, we will have to see that if someone else has a patent for 20 years for the product,
Yeah.
and if he covers that this particular product cannot be produced by anyone else through any other method, I mean we will have to see that how the claim of that particular
Okay.
product has been written if the patent is existing.
So the government does not provide some relief in this case, that product or drugs should not be given on the final product, but only process. Because
So
the
for
drug may be important and some company may have some monopoly on it.
no, government is very supportive. Government is very supportive in that case, but everything will have to be checked as per the laws. So if we, simplify your question, the answer would be in 2 steps. First of all, check whether the product is off patent or not. If the product is off patent, which means all the different kind of process they can have the patent on. So right now also there are so many patent on different process for obtaining a particular chemical compound. So it is possible. But when your patent, I mean someone else patent is active on a particular chemical compound or a particular chemical product, we will have to see that how the claims are written. Let's say if the claims are written very strongly and they have a very good protection which prevents or restricts anyone else to not manufacture that particular chemical through any way, then the other people will not be allowed. But otherwise, for specifically for pharma and medicines, so we have a specific section called section 3D, so which says that if a particular patent is already there for a particular molecule, then the derivatives or salt or ether of that particular compound, it cannot be granted a patent unless there is a enhanced therapeutic efficacy. So this particular section is to prevent the evergreening of the patent that was happening sometimes ago. So this is one important aspect, and pharmaceutical patents, they are always a matter of debate, and always something is happening.
Thank you so much for enlightening.
Thank you, sir.
Ma'am, you said that evergreening of the patent के लिए मतलब new clause our patent office is coming up. तो मेरा but doubt छोटा सा यही है कि क्या जो भी ड्रग डिस्कवर किया गया है, if we change the method, अगर हम रूट ही डिफरेंट कर देते हैं, then that can also be patented. For example, a chemical compound can be synthesized using the 2 different routes. So that 2 different route can also be patented, or the chemical compound only.
Correct. That different route can be patented if that route is different from the one which is already there. और ये जो section 3D है, this is not new. This was already there in our patent act. So this is This was already there, and it helps in preventing the continuous evergreening of the patent.
Ma'am, you also gave the very good examples of that, like something is in US, not in India, can be patented.
Yes, this is very
Please make
important because लोगों को यही लगता है कि वहां नहीं है मैडम, यहाँ तो कभी नहीं हुआ है, and they are very excited when they discuss it. फिर हमें उनको बताना पड़ता है कि नहीं सर, अगर वहां पे है then also you cannot get a patent in India. It should be new.
मैम पीछे एक ऐसा डिबेट चल रहा था that US trying to patent the yoga. Actually, that is in India, but they are trying to patent it.
हाँ, तो उनको नहीं मिला फिर.
Okay. Okay. So, any other question? Thank you again, ma'am, for the answers of the question and this great slide. Now, I would like to request our IQAC coordinator, Dr. Neeraj Tiwari, please conclude the session.
Thank you, Aman. It was a very nice session, and I am grateful to Suvarna ma'am. In such a short time, she gave her valuable time and provided very valuable inputs, and in a very succinct way and with clarity, so that students as well as faculty may have a grasp on the subject. And we will seek further cooperation from her in future. So thank you, ma'am. Thanks a lot. I also thank the team members, Aman, Arpana, and other IQAC members, and our principal sir also. He might be busy today. A meeting of NEP is going on. So thank you all, and most of all, I thank the audience to hear patiently, and they have given their time, and our faculty members as examinations are also going there. Thanks a lot, and it was a very valuable session, and we'll try to have more further sessions on the related field, especially on GI tech. We want to conduct one more session, and we'll seek Dr. Suvarna's advice in the future. Thank you all. Thanks a lot.
Thank you so much. I also want to thank you.
Thank you, sir. Thank you. Thank you very much.
Those who have not filled the feedback form, please fill it. जो भी participants ने feedback form नहीं भरा है, please भर दीजिए. So this conclude our seminar. Thank you so much. कितने लोगों ने भरा है? Please fill the feedback form for getting the e-certificate.
those are yet to fill the feedback form. It is available in the chat box